SC, may we please check with you if the witness appearing before us is the appropriate guest that we expected.
Thank you, Honourable Chair, Honourable Committee members. Yes, I can't vouch for Prof. Cachalia's bodyguards, but I can vouch for him. I met him, we consulted with him, and I also known him prior to this, and I can confirm it's the Acting Minister of Police that's in front of us today, Chair.
Okay, thank you so much. I can also see that is Professor Cachalia. I served with him in the National Executive Committee of the ANC previously. I know him. Honorable Skosana.
So you say I can...
I want to hear if you are satisfied with the statement that has been made by...
Yeah, indeed, Chair, but as you said that we are waiting for Prof to be sworn in first. So, yeah, thank you, Chair.
Oh, you want him to make a declaration once he has been sworn in that the people that he is with are proper people?
Yeah, because really we are scared now because we don't know whether these are policemen and, or... Yeah, but thank you, Chair.
But I don't see anybody behind him. What is happening? Okay. No. Let me move to welcome Acting Minister Cachalia. We are going to move to the next item, which is the administration of oath. And before I do the administration of oath, I must read the following, that you have been invited to appear before the ad hoc committee, which is investigating the allegations that were made by KwaZulu-Natal Police Commissioner General Lieutenant General Nhlanhla Mkhwanazi, and that you will provide us with information that will help the committee to do its oversight work. The committee is investigating, amongst others, allegations which include the alleged unlawful disbandment of the Political Killings Task Team, otherwise known as the PKTT or the NPKTT. Alleged moratorium on the filling of vacancies within the SAPS, the South African Police Services, and alleged corrupt relationship between senior leadership within SAPS and members of the public, as well as political interference in the work of the SAPS. In extending these invitations, the ad hoc committee chairperson has indicated that you may provide such information to the committee if you so wish under oath in terms of the powers, privileges and immunities of Parliament and Provincial Legislatures Act. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to provide any document that you are required, to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. Acting Minister, you are, however, protected in that evidence given under oath or affirmation for a House or Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17.2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who will fully furnishes a House or Committee of Parliament with information or makes a statement before it which is false or misleading, commits an offense and is liable to a fine or imprisonment for a period not exceeding 2 years. You are required to take an oath or make an affirmation that the evidence you are about to give is truthful. And let me check with you, Honorable Minister, if you elect to take an oath or affirmation.
Affirmation.
Affirmation. Thank you so much. You will then follow me by saying I. Acting Minister, may you please say I and then state your full names.
Firoz Cachalia.
Solemnly affirm that.
Solemnly affirm that.
The evidence that I shall give.
The evidence that I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So I do.
So I do.
Thank you so much.
Thank you.
Thank you so much, Acting Minister. I'm handing over to you, SC. Honorable Skosana, the matters that you are concerned about, I think the security team will deal with those details. In the event there is any other person here, where you are seated, I don't see you being exposed to any danger. The person who is facing the entrance is me, the chairperson. Okay, SC, we hand over to you to start leading evidence. Thank you so much.
Thank you.
All the best to you and Minister
Honorable
Cachalia.
members, everyone present. Minister Cachalia, good morning. And thank you very much for your cooperation and your input into the statement, despite an extremely busy schedule. You've been thrown in at the deep end, and I'm not sure whether you've been handed a poison chalice, but by all accounts, you've come to terms with your position quite quickly, and we wish you all the best. Having heard thus far quite a number of quite disturbing developments within the senior management of the police. But just to start off with, so that we can get through this quickly, the statement has been made available to the honourable committee members, so it is in the statement. But just to run through it quickly, you have quite an impressive array of legal degrees, diplomas, LLB, LLM in various areas of the law. You've also been appointed as an adjunct professor at WITS, and you're the director of the Mandela Institute. You've also been admitted as an attorney of the High Court of South Africa. You've also, in fact, practiced few years. And probably one of the more important credentials is that you participated in the struggle for national liberation. I think you've also seen the inside of a prison, having been detained, and then subsequently to deliver our new democracy, you had served in CODESA as a constitutional expert. So I'm not sure how you're going to avoid the committee members' questions about interpreting certain sections of the Constitution today. You also have experience as an MEC between 2004-2009 for community safety in Gauteng. And during that period, you would have interacted with the police. So you have that background. So just before we move forward or onward, any comments that you wish to make in terms of your own background experience, either because you seem to straddle the academic world, the private sector, and also, of course also one of public service?
Yeah, all of that has brought me to this point, and I'm not sure how well prepared I am, but I will intend to tackle the challenge that lies before me. Thank you.
Just speak a bit up, if you don't mind.
It's not on.
Sorry?
Is the mic on?
Yeah, I think the mic was on. Yeah.
I was just saying, Advocate, that I'm not sure if everything that I've done up until this point has fully prepared me for the challenge that I have, the duty that the President has accorded me. So, but I will use the attributes such as they are that I do have to tackle the challenge that lies before, I think, the South African Police Service and in fact the country as a whole.
You were appointed as acting minister on the 1st of August this year, though it's just a few months ago. And prior to that, or what gave rise to your appointment, was, amongst other things, the revelations that came out of a media briefing held by Lieutenant General Mkhwanazi on the 6th of July. And that seems to have precipitated the placing of Minister Mchunu on special leave, and then your subsequent appointment on the 1st of August. What was your reaction to that, just briefly?
The reaction to his statement or my appointment?
To the statement of the 6th. Clearly you had, I'm sure, no idea that you would be appointed at some point as Minister of Police.
Yes. I now learned that General Mkhwanazi appeared before the Portfolio Committee, I believe it was on the 5th of March, where he shared his views publicly for the first time. I have to say that while I was in the academy reading cases and journal articles, I wasn't paying that much attention to specific issues for Parliament, and so I was unaware that he had made some of those statements previously. After his appearance before the public, in full military regalia, armed and so forth, worried me. And I made a statement to that effect after my appointment. And I said at the time, which I maintain is correct, that was that kind of public statement was not in the ordinary situation, in the expected situation, appropriate, because the police have a command structure. There's a national commissioner, and there is a minister and a president and so forth. And ordinarily, I think professional conduct requires respect for that structure of authority. But I also said that should his allegations be sustained, his very worrying allegations about the infiltration of criminal cartels into the police service, into the political process, and so forth, if those allegations were to be sustained, then he would have been vindicated. So in that sense, he would have been shown to be a whistleblower. And so when senior officers who are ordinarily expected to adhere to those principles, where extreme situations arise, such as we are now in, and those norms are not working to achieve the results that society expects. One expects bold, courageous conduct by those who hold important positions in our society, to tell the truth as they see it, whatever the consequences that might be visited on one personally. So, I think subsequently one can say that I've been listening I listened to parts of his testimony to the extent that I could before the Madlanga Commission and before yourselves. And the testimony, his testimony and of others, particularly I think before the Madlanga Commission, those three witnesses that testified in camera, are very alarming, very concerning. But of course, neither yourselves nor the Madlanga Commission has come to conclusions, and so for the time being, my own posture is that despite the concerns that I have, and I think the public has about the evidence that's already in the public domain, my own posture is that I will wait for this inquiry and the Madlanga Commission to come to conclusions that are properly assessed and tested before I make come to a final understanding of what's really happened over the last few years in the South African Police Service and more generally.
Thank you, Minister. Have you subsequently, or did you subsequently meet with Lieutenant General Mkhwanazi and some of the senior management in SAPS to share and express those concerns that you've just articulated?
No, my engagements with first of all the National Commissioner have been about the issues that lie before the South African Police Service. Initially, I think I was trying to understand what exactly happened with the PKTT, what reasoning informed the decisions that my predecessor made, his relationship with the National Commissioner, and what had happened with whether that team had been disbanded, and if so, what had happened with the dockets. I was concerned that, I mean, it was in the public domain that task team had been disbanded. I wasn't clear about the reasons. And I wasn't sure what had happened to the dockets. Now, those dockets were, the dockets contain evidence of ongoing investigations at different levels of finalization. Some of them I assumed were matters that required ongoing investigation. Others might have been concluded at the point of prosecution. And it would have been a concern to the families of those who had been killed that these investigations should be reliably concluded. So those were some of the issues that I engaged with the National Commissioner on. I did meet...
Minister,
Sure.
Perhaps if you want to just go straight to that, you deal with that from page 13 onwards, my interaction with the National Commissioner. Perhaps just take us from paragraph 31 onwards. And then you'll also deal with the issue of the dockets and the PKTT, some of the reasons that informed the decision to disband, disestablish, was it disestablished, and what your interactions with the National Commissioner brought about.
Thank you. So I suppose I should read those parts of the statement into the record. At paragraph 31, I say, I discussed the matter of the National Police Killings Task Team with the National Commissioner in 2 meetings. The second one occurred in the presence of Provincial Commissioner of Natal, Lieutenant General Kwanazi. And that took place on the 20th of August. The meeting, that meeting followed a meeting that I had with the senior management, all the provincial commissioners, the divisional commissioners, and after that meeting, so obviously the provincial commissioner was present in that meeting. The National Commissioner, I took an opportunity to have a brief meeting after that, and General Mkwanazi was invited into the meeting. And in that meeting, we did discuss this matter of the political of the team and what had happened to the dockets and so forth, but very, very briefly. My main interlocutor, obviously, was the National Commissioner. So let me see if I can deal with this from memory rather than to go through, to read the statement. So obviously I was concerned about this matter because it was in the public domain. And as I've said, I was concerned about what really had happened and what had happened to the dockets. So I raised the matter on at least 2 occasions with the National Commissioner. I was trying to understand whether the task team had been disbanded or not. And if it had been disbanded, what had happened to the dockets, which after all are collections of evidence, products of ongoing investigations. So the safe custody of the evidence was of a crucial matter. I have to say that it took the 2 of us, myself and the National Commissioner, some time to get into a position where I understood exactly what he was communicating to me. And having listened listened to his evidence before the Madlanga Commission and before yourselves, I do have a better understanding in retrospect. So,
But what was the blockage? What was the basis for what appeared to be difficulty to understand what was happening, especially with the dockets?
well, you know, I mean, when there's verbal communication on a complex matter, which has occurred in the past, the National Commission is trying to explain to me, someone without knowledge about what's happened in the past. There was sort of, if you like, I think, a natural communication gap. The commissioner, you have to remember that he was in the position where his relationship with the previous incumbent had broken down, and there was self-evidently some tension in that relationship. So here you have a new person, a new minister, appointed to step into the shoes of the previous incumbent. So I'm speculating about why it took us, you know, certainly, I think by the 20th of August or so forth, we were more or less on the same page. So it wasn't clear to me from his initial responses that the team what had happened, whether it had been disbanded or not. Eventually, I did have access to the letter that was written by Minister Nchunu of the 31st of December. And the National Commissioner did complain to me, did communicate that he felt that letter, rather a cursory letter on the 31st, on New Year's Eve, effectively, while he was on leave, was not, in his view, the appropriate way for dealing with such an important matter. But I was trying to understand, had the PKT actually been disbanded? And he was it was a little bit unclear to me that I was getting a clear answer on that question.
Did you ask him for a report then?
I asked him.
I just wanted to reference, I'm not sure whether it's before or after the meetings you had with him, but your letter addressed him of the 20th of August,
yes,
2020.
So eventually I addressed that letter to him precisely because I felt I still didn't fully understand. And so I addressed the letter to say to him, look, please, I now want your report in writing. I want to understand what happened, and I want to understand what plan you've put in place. Because it did become clear over time that he, although he disagreed with the minister's decision, he decided to accommodate the minister's instruction to the extent that he advised the minister to agree that the dockets should be, there was some public reporting that the dockets were in the hands of General Sabir, that he explained to me that he had advised the minister that fine, you've said it should be disbanded, but the docket should be transferred in a systematic, incremental way, so that I assume to ensure that the integrity of those case dockets was preserved. So I now understand more clearly that he had decided, to at least to that extent, to agree with the minister. And I understand that in the exchange between the National Commissioner and the Minister who has executive authority, that there is a negotiation, if you like, an attempt to find an accommodation, which is what I think the National Commissioner did. And so I think it's now clear to me, or it became clear by the time, by the middle of August or so forth, that in fact the PKTT had been disestablished and that the dockets were being on a planned basis, on a phased basis, being transferred. I still was not satisfied because I still didn't understand exactly where the dockets were, who had custody of them, what
So,
steps.
so Minister, where did, is it in that period that there were media reports and that you and the National Commissioner had a difference of view or approach on the issue of the 121 dockets? You want to just clarify that?
So then I asked for, because the matters were still not clear for me, I asked him for a report in writing, and as I indicated in my letter, and I got that report from him on the 20th, I think it was it the 20th? Just see. So my letter is my letter was on the 20th of August. Now, I hadn't yet received the report. When I saw a statement that the National Commission had made in public, in comments he made to the media, that the dockets had been transferred back to KZN. Now, that was inconsistent with my understanding of what he had conveyed to me, that the team had been disbanded and that the dockets were being transferred according to this disestablishment plan. In addition, I was concerned that this matter also fell within the terms of reference of the Madlanga Commission. And the safekeeping of those dockets would also be of interest to the Commission, and the Commission would surely be in a position where it has to issue instructions about how those dockets would form part of the inquiry before the Madlanga Commission. So it wasn't appropriate for the National Commissioner to make that public statement before providing me with the written report that I had asked for. After several weeks of trying to understand clearly from him what the position was. It would now appear that from his evidence that on the 18th of August already, that's before I wrote my letter on the 20th, that there'd been a written communication, at least according to his testimony, between him and the National Commissioner, the Provincial Commissioner in KwaZulu-Natal, that the dockets would be transferred. So what he was communicating to me and what he actually did was not consistent. But I treated that more or less as a communications problem. He might have made the statement in an offhanded way under pressure from a journalist. That happens. All of the members here can understand. Sometimes you find yourself in that position. And so my approach to the matter subsequently was to call a meeting with him. We had that meeting to clarify roles and to indicate to him that given the challenges that SAPS faces and the concerns about the country about the developments in the South African Police Service, the breach in the public trust, that it was very important that him and I have a respectful, transparent relationship, that's what we needed to communicate to the public, that the minister and the national commissioner, who has enormous responsibility in this moment, particularly in SAPS, that we are pulling together, that we are working together. And I think that subsequent to that moment, our relationship has strengthened. We have a respectful relationship, and we're working well together. But I had to establish also with him my expectations about how the relationship should be conducted going forward.
And you subsequently did, in inverted commas, resolve the issue of the 121 dockets, and you also subsequently issued a joint statement.
Yes, he then there was I received the report. There is a date, but subsequently, not too long. It was somewhere in the middle of August, so not too long after I made the request for a written report. I did receive that report. It's obviously that report has a classification. But I have read, of course, I have read the report, and in that report, he made recommendations, essentially recommending that, in his view, the task team that had been established should continue to exist, so in a sense, re-established, and that similar capacity needed to be developed, and that he was in the process of doing so in Gauteng, because from my own observations, but I'd also had I had a meeting with Premier Lessufi to communicate with me his concerns about political killings in Gauteng. He came to see me immediately after 2 ANC councillors were killed in Soweto, which also concerned me. I was also, I've had a growing concern about the assassination of whistleblowers. Of course, we have the famous case now, infamous case, if you like, of Deokaran. But I mean, we've had a number of, we have that young man murdered in Ekurhuleni, an auditor. We've had even private professionals being assassinated. So my perspective then, by this point, was the following. I couldn't understand exactly what the reasons were for the disbandment of the task team. It seemed to me that the problem of, let's call them political killings, I'll come back to that, was an ongoing one, that in the run-up to the local government elections, it was likely to deepen, become even worse. And the fact that whistleblowers were now increasingly vulnerable in our society, public officials, not only politicians. So I think that what we now need is a strategy to fight organized crime. This is not a problem localized in one province, and it's not restricted to political, what we might have called political killings in an earlier period, if by that is meant the killings of politicians. So I think the problem is a deeper one now, and we certainly need, on a national basis, to respond to this problem of the involvement of cartels infiltrating our institutions, increasingly emboldened, quite prepared to assassinate people, apparently without consequences. So many of these cases don't get properly investigated. And so, you know, I think that it's now a national question, and we can certainly learn from the good practice of the political investigations political killings task team, because that task team's work was based on an integrated approach to the challenge, an organized crime approach, if you like, which brings together the investigations, the prosecutions. There were prosecutors, dedicated prosecutors, who were deployed to that team. Now, to deal with the challenge of organized crime, that's exactly what we need. And I think that the criminal justice cluster always struggles to overcome the silo problem, to get different parts of the system working together to tackle a challenge. And so I was quite happy with his recommendation that was contained in his written report, that that team should not be dismantled in the current moment, but we do need to have a conversation, and we are having a conversation about how to tackle a problem that I think is broader and deeper than perhaps it was 4 or 5 years ago.
And that arrangement, agreement with the National Commissioner, is summarized in that media statement of the 2nd of September.
That's correct.
Is there anything you want to highlight from that statement that you haven't mentioned? Or that's recorded there? Yeah.
Thank you, Advocate. I do discuss, I think I do discuss this issue that is so pertinent now before the Madlanka Commission and yourselves, provoking so much interest about roles, the respective roles of a minister and the head of a department, an accounting officer, in this case, a national commissioner. And I suppose that was my effort to deal with the matter in a way that I think is the right way, which is to say that you respect each other's roles and responsibilities, and you find a way to work together, because the system can't work. The system of having political heads who have executive authority over departments that are headed by professional managers, HODs, accounting officers, and so forth, can't work if that relationship breaks down. And it's always potentially one that can break down. And when that relationship doesn't work, the impact on what government is trying to achieve and what the public expects is compromised.
So it would perhaps not be fair to ask you what your reaction was or would have been to the letter of the 31st of December 2024, but what you now know in your interaction with the National Commissioner, and also what you've gathered from several meetings about the directive by Minister Mkhunu to disestablish the task team, much has been made here of the word immediately. How would you have approached such a matter? There are 3 matters. There was the ports of entry. There's also the issue of a moratorium on the filling of posts in crime intelligence, which is also very, very worrying. And then the issue of the political killings task team.
Well, you know, I cannot put myself in the position of my predecessor, and I don't think it'd be appropriate for me to second guess the decisions that he made. Because even when one makes misjudgments, one makes decisions that perhaps are difficult to judge in retrospect, they might well have been made in good faith. Of course, because all of this is in the public domain now, everyone out there has an opinion about this matter. But I want to be responsible and appropriate in the way I, as the minister who has succeeded him, deals with this matter. But I would say that to take such an important decision required sound reasoning. The reasons for a decision like that. And there could well be a situation where there are good reasons to make a decision like that as the executive authority. In this case, now I know from the report that I received from the National Commissioner that this matter originated with a presidential decision. The president established a interministerial committee. And what informed that decision must have been that the president was of the view that this matter is of some urgency and that it required the combined response from several ministers and ministries. That the matter couldn't just be tackled by the police. Which is certainly my view, for instance, say, with organized crime in general. Now, it is so that when one administration succeeds another, committees of the cabinet are reviewed and reorganized as portfolios are reorganized. So it is interesting, or it should be of interest, that this interministerial committee, which had been established in the 6th administration, I believe, had not met for about 2 years when my predecessor made the decision that he made. So it's not clear to me that that interministerial committee continued to exist. That maybe is a question of fact. But I think I would have taken the view, and it's easy to be wise with hindsight. I think with hindsight we can say that there ought to have been consultation with with colleagues in the cabinet whose judgment about the disbandment of such a team, such an initiative, would have been essential, I think, to arrive at the right decision. There ought also to have been proper consultation. Rather, let me put it this way, in a situation like this, so that I'm not in a position where I'm commenting on what was actually done in a specific factual situation. But let's say in a hypothetical situation with more or less the same facts. I think that what the situation does reveal is how important that mutual respect and consultation between the two heads of any institution are. You can think about the chair in the private sector, maybe the chairperson of the board and the CEO. If that relation breaks down, the functioning of that institution is compromised, and it's no different in the public sector. So, you know, in this respect, I did listen to the evidence of former Minister Cachalia. There's a lot that he said that I wouldn't associate with specific matters. But on this matter, I think he was correct to the extent that he was emphasizing the fact that this decision was a political decision. Now, surely, task teams with specific mandates are time-bound. They're not immortal. No government program is immortal. It's subject to budgetary decisions, changes of priorities. So from my point of view, the main issue is not that the task team, that the minister took the view that the task team should be disbanded. It's that how it was, the process that was followed, how did he arrive at that decision? Who did he consult with? Were the reasons sound? There could have been reasons that would have justified that decision. And then how the decision was communicated is where I think the main questions are. So I can talk at some point if it's necessary about the constitutional and legal questions. I have reservations about framing the matter in those legalistic terms, but we can come to that. So in my mind, the main question is a question about decision making. It's about roles and responsibilities and how a particular kind of decision was made. So in the circumstances, it could well be that the decision was the wrong one because of the way the decision was arrived at and the way it was communicated, which is why we sit here today.
So, do I understand you to say also that there isn't necessarily a bright line between executive authority and operational management, especially in a portfolio like what you have, because an operational decision may, for reasons that it impacts on executive authority, that the better way to deal with it is through a consultative process.
Yes, Advocate. I have prepared some detailed reflections on this relationship, which I could go into or share them with the committee subsequent after this hearing. The one thing I would say is that I think that the communications between the minister and the head of the department, whether in SAPS or any other department, as much as is possible, should be in writing. And perhaps in writing in the sense that both parties should understand that those are, in a sense, public communications, like my letter to the commissioner, which is now before you. So that there is I think that way you discipline the conversation. It becomes more, it's not informal, it's a disciplined, professional conversation. It's in writing. So, if you're making such a decision, you motivate the decision properly, and the response from the National Commissioner or a head of department should also be in writing. Where the head of the department believes that a minister has issued a directive or instruction which is unlawful, the head of the department or the National Commissioner in this stage should insist that the instruction is in writing, that it's properly motivated, and if it's an unlawful instruction, I think the head of the department should respectfully decline to implement the instruction and insist that the minister issue the instruction in writing. But let me speak to this question, the legal and constitutional question, which, as I say, I think that sort of legalism is not always the resort to legalistic arguments doesn't help resolve what are complex questions. In all jurisdictions, everywhere in the world, and in all departments, this question of the relationship between the minister and the accounting officer is a fraught potentially fraught relationship. It's potentially a difficult relationship. And in my view, it is not susceptible to detailed specification, definition, and regulation, because it's a relationship. Now, some commentary I've heard purports to find a clear, bright line, definitional answer to this question in the Constitution. That view says that the Constitution is prescriptive and clear. The Constitution defines what is within the minister's domain and what is an operational matter. Now, with respect, if I'm going to make a legal argument, I will say that I would question that reading, that interpretation of the Constitution. So if I look at my eyes are failing me. The most cited provision, 206.
206, 207.
And 207. 206 defines the member of the cabinet's responsibility for policing and must determine national policy after consulting provincial governments and so forth, and taking into account policing needs and priorities. So that's political responsibility. Interestingly, it doesn't label it executive authority, because I think that that formulation correctly reflects the fact that the minister embodies, in a sense, in the theory of democracy, the will of the people. They carry a political mandate, and Parliament holds the minister accountable for that mandate. That connection between the government, this Parliament, and the people is critical in a democracy and must be weighed in our reasoning about this matter. Then 207 says the National Commissioner must exercise control and manage the police service in accordance with national policy and directions of the cabinet member. Now, that rather general language doesn't in detail instantiate the relationship between these two important positions. There is no reference to operational matter, to what is an operational matter and what is not in the Constitution. That is a matter, it's not a textual matter, it's a matter of interpret. That's how the Constitution is being interpreted, how this language is being interpreted. So I'm making 2 points. One is that there's no reference to what is an operational matter and what's not in the Constitution. That is a matter of extra-textual interpretation. It's an expression of an opinion about what the Constitution provides. And Section 206 and Section 207 don't resolve this matter in any kind of detail.
Well, it seems to also complicate or compound matters, because 207.2 then says that the management and control must take place in accordance with national policy and the directions of the cabinet member responsible for policing.
Quite right, Advocate.
And what if those directions, like the one of 31 December, have some control management features or aspects?
Yes, and so I think that you are quite rightly drawing our attention to the complexity of the matter and why simple, definitional, categorical, binary mechanical reasoning doesn't resolve the matter. What is a policy matter and what is a matter for management? Okay? You can think about any program in government which is set up in the Department of Education or the Department of Welfare. There are programs there that are funded and which the minister has oversight over. And the minister might well decide, we're in a new administration, we have new priorities, we're going to cut the spending to higher education, we're going to prioritize basic education. Those are, and then the accounting officer and the minister have to work together to implement what is a directive from the cabinet, surely. Now, I would make a second point. I think it's always wrong as a matter of constitutional interpretation to treat each provision of the Constitution as separate and discrete. Provisions have to be interpreted in the light of their purposes and, where necessary, holistically in the light of other complementary provisions in the Constitution. So I hear arguments which entirely ignore Section 83, which I think is material, which says that the President is the head of state and the head of the National Executive. Section 85(1) says the executive authority of the Republic is vested in the President. And that the President exercises the executive authority together with the members of the cabinet. The Minister of Police is a member of a cabinet. It's a collective body. And then the provisions relating to the cabinet, Section 91, the cabinet consists of the President as head of the cabinet and Deputy President and ministers and so forth. Now, my point is this. How can you interpret Section 206 and 207 without reference to those other provisions which envisage a system of representative government, of cabinet government, of which every minister is a part? So when a minister exercises executive authority in a department, that minister is exercising that executive authority on behalf of the President and as a member of the cabinet. So how can this matter from a legal constitutional point of view be treated as if the Constitution provides a simple mechanical answer derived from the rather general provisions of Section 206 and 207? Constitutions are not written that way. Constitutions are frameworks. They are not prescriptive in the way that is being suggested by this reasoning. And frankly, I don't think we can resolve the matter fully by assuming that we can draft legislation that will resolve the matter. So I would say this. I think it's a complex relationship where it works for the department to work well and for the government to deliver on its mandate. These are two critical positions. When they break down, then the institution atrophies and the ability of the institution to function and to deliver on its mandate breaks down. And there may be many reasons for that breakdown. I think that's what we've seen here. Rather than to treat this question prescriptively as if we have a formula, a definition that is going to resolve all such matters going forward in the future. And by the way, I would also say this. We should, some of these formulations appear to me to be rather conservative. They are orientated towards protecting a status quo. In a situation which requires change, where dysfunction has to be addressed through reform, how does this formula, this mechanical formula, assist us? In the next 2 years or 3 years, am I going to be called before the minister, before yourselves, and before a portfolio committee, and to be said, well, I will say, well, 90% of these decisions were made by the provincial commissioner, by the national commissioner, and they were all operational matters. So you can't hold me accountable. Hold him accountable. And so I think there's also an accountability deficit. It allows this formulation, I think, allows both the minister and the head of the department to escape responsibility and accountability. Because they can always say, as a matter of definition, that matter belongs to the minister and not to me, and vice versa.
Yeah, it depends on the context and the purpose, and of course, the break on both executive authority and control and management is always going to be the principle of legality and issues of rationality. What informs a rational decision are the reasons that you give for those decisions. You can't simply make a decision because you woke up one morning, maybe on the 31st of December, and you just make a decision. You've got to give reasons that informs that decision.
Yes, thank you, Advocate. I think that that it's not clear to me also, but this is a small quibble that I mean, when you are dealing with political responsibility, that you can apply the principles that are applicable to administrative decisions fully, like Paja and so forth. But I do think that good decisions, whether by the National Commission, by the head of department, or by a minister, and decisions, whether you're in the public sector or the private sector, are best when they're made through a proper process and with proper reasoning, what you call rational decisions. And then we should be able to scrutinize the decisions. And the fact that you are you hold an elective office, doesn't exonerate you from political responsibility as opposed to legal responsibility for the way you make decisions. Because I think that it's quite right for members of the legislature to scrutinize decisions, especially important ones like this, to scrutinize the decisions, and to explore what the reasons were, whether the reasons were sound, and then how did you go about establishing those reasons. You can't simply, you can think you have reasons, but you can be very subjective. So I think often it's best to have a rational process of inquiry, of fact-finding, of thinking carefully about what the criteria are, what process do you have to follow to put yourself in a position to make the right decision. From myself, speaking very much for myself, I feel that's the way one should try and come to conclusions about any matter, but particularly when you have such important responsibility.
Now, just to go back to the Interministerial Committee, we know from former Minister Tele that actually the last Interministerial Committee meeting was in May of 2024, just shortly, I think, before the elections of 2024. And he also mentioned to us that he had seen some assignment to Minister Kubai, who's Minister of Justice and Constitutional Development, that one of her assignments related to the IMC. You haven't received or seen such an assignment?
Sorry, no, I haven't. But the two of us jointly chair the JES CPS cluster, and we've had to work very closely together on this anti-gang strategy, for instance, precisely because, as I say, I think this integration is so critical. We've had to work very closely together. So, I mean, certainly often on matters that come before me, I find that I've got to consult with her. There are other colleagues in the criminal justice cluster, Minister of the Security Agency, Corrections, and so. But yes, I have a close relationship with the Minister of Justice, and it's necessary for our work.
Is it given your grave concerns, which I think all of us share, of political killings in not only in KZN but in Gauteng, in other areas of the country, and that seems to be linked to organized crime, that you should convene an IMC or ask the President to convene the IMC again so that it can take stock of what the political killings task team has achieved thus far, because as we know from the evidence, the political killings task team has now only been funded up until March 2026, which is like just a few months away.
I think that's an excellent suggestion, Advocate. We are working on...
I've got no ambitions to be a politician.
You'd make a very good one, because you reason in a rational way. No, I think that's a good suggestion. It has been at the back of my mind. We are working on an organized crime strategy. We are testing it out in the Western Cape and in 3 other provinces. This integrated strategy, and as I said, we learned a lot from the PKTT, I think that there is a gap in the current structure of the cabinet. I would say that the JCPS cluster perhaps is not the right forum for an initiative like this, which requires a very clear focus, almost a project-like focus on investigation, prosecution, and so forth. So I think you are correct, but of course I will have to consult.
Because no doubt, Honourable Minister James will ask you about the rife killings that are taking place almost daily on the Western Cape, on the Cape Flats, in Reiger Park, and other places. Why isn't the same integrated approach where you have investigators, prosecutors all working together? Why is this not being applied? And I think you did mention, I'm not sure if it's in your statement, but in our consultation about how you've asked or requested, what plan is there in place to deal with this, particularly when you were here, I think a few weeks ago in Cape Town, Cape Flats?
Well, in fact, there's been some progress since we met, because when I got back to Gauteng, I immediately had a conversation with Minister Kubai. She convened a meeting which took place in her department. Not at the level currently that they need to be. Detective services is one. And you are pointing out the fact that even when we do recruit and train the best, we lose them. And by the way, one of the problems is that, because we don't have an integrated approach in the criminal justice system, you have the best detectives are poached. They go to the private sector or they go to the SIU. And so you can't build IDAC because they want to work at the SIU, because that is a well-functioning institution, and we've all seen the results. Crime intelligence needs an upgrade. Does crime intelligence have the analytical capabilities that are required to deal with organized crime? So I think there's some conversation to be had about how to assure alignment and integration of the criminal justice system through common performance standards, for instance, common targets, budgets, and so forth.
Honorable members, the SC is requesting that we take a 5 minutes break.
Thank you.
It's
Thank
now it's now 28 minutes after 11. So we will come back 20 minutes before 12.